Hello, welcome to part 2 of the Patent Basics series from PIUG, Patent Search Types. I'm John Zabilski, a Director at Large at PIUG and also Chair of the PIUG Education Committee and a registered U.S. patent agent. PIUG is the Patent Information User Group, a not-for-profit organization for those interested in patent information. And the mission of PIUG is to help assist those individuals and through leadership, networking, and education. Now, when running a particular patent search, the type of search will influence the approach that you need to do. For patentability, or sometimes referred to a novelty search, you will search all document types anywhere in the world. This will include both patent documents as well as non-patent literature. There'll be no limit on the date range. You can go back all the way to the first printed document, the Gutenberg Bible, if necessary, to support your case. Another common search is freedom to operate, or sometimes called freedom to practice or a clearance search. In this case, the search is focused only on in-force patents. Frequently, it would be restricted to specific countries or regions. And most often, you will use legal status information to determine if it is still in force. Has it been withdrawn or abandoned? Has it expired? Has it paid its maintenance fees? Those are some of the issues you would find out by doing a legal status search as well. For validity or invalidity search, or sometimes called an infringement search, you also have a thorough search on all document types. Here you care about a particular date, perhaps the priority filing date of a document, or a potential infringement patent, or perhaps a date that predates a particular filing to prove that a granted patent should never have been granted. The last one we're looking at here is the landscape or state-of-the-art search. Typically, there's a big data set involved in this. You're trying to investigate a particular area of technology and using visualization or analytics, including landscaping or mapping of the data to understand that large set of data. Well, a patentability search involves finding prior art. So prior art includes all documents from anywhere in the world. Of course, it includes granted patents or published patent applications, but also any other publicly available document, no matter how old or obscure or hard to obtain. These would include journals and conference proceedings, but other printed documents as well, including dissertations that are buried on a dusty shelf in some university. And of course, now internet postings qualify as well. Now, if you're interested in more information about searching, prior art searches, and some details and techniques for doing that, PIUG does offer an essential patent search techniques course under our fundamental series. And that's available again on our education and training page that you see here on the PIUG website. Now, from the U.S. patent searching standpoint, the examiners would use the Manual of Patent Examiner Procedures, or MPEP, and here's some general search guidelines from section 904.2. So planning a thorough search of prior art would require 3 distinct steps. You, of course, would identify the field of the search. Then you'll pick proper tools to perform the search. So that would be the search techniques that you're going to use, the search engine you're going to use. And then you determine an appropriate search strategy for each tool that you selected. Each step is critical for a complete and thorough search. So 3 reference sources must be considered. Domestic patents, of course, those are the U.S. patents in this case, including patent applications that were published. Foreign patent documents and non-patent literature. This would cover the claim subject matter, but also look at the disclosures. What other features might reasonably expect it to be claimed, perhaps in a further pending filing, such as a continuation. So for a freedom to operate, or FTO search, this is an also comprehensive search, but targeted just at in-force patents. So you're going to be focused on granted patents, but you can't ignore pending active applications in the geographic area of interest, because they may become granted patents in the future. So frequently do some kind of current awareness search in the freedom to operate, or search at various stages of development. You will search the claims text, focusing on that text, or perhaps use classification codes that are based on the content of the claims. Or various vendors have indexing that is derived from the claims text as well that can be used. As mentioned earlier, you'll also take a look at legal status to make sure that particular patent rights are still in force. The targeted goal is to avoid infringement on another's in-force patent in a geographical area of interest. For more information about these particular searches, you can look at best practices for identifying freedom to operate, or look at the legal status section of our fundamentals course, again on our education and training page. So the PIUG Education and Training Committee provides live training, webinars on demand, and online training. For more information on PIUG, go to the website at piug.org. More information on our training sessions, go at our education and training page. And if you have any questions on PIUG or training opportunities, including customized training, you can contact education@piug.org. Thanks for listening, and stay tuned for part 3 of this series.